Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Welcome to Legally Speaking. I'm Melanie Fanada, your host and paralegal at Aitken Robertson. And joining me today, we have defense lawyer Channdeep Singh Nahi. And we will be answering a question that we hear, quite frankly, all the time. Can a judge replace a criminal DUI with a careless driving if you plead guilty? Channdeep, let's begin by clarifying what exactly is impaired driving.
So, impaired driving basically means when an individual's ability to operate a motor vehicle is impaired to any degree by alcohol or drugs. That's called impaired driving.
That includes DUI, impaired, 18 over, refusal, and all the other criminal crimes?
Yes, so impaired, so there are two offenses in the Criminal Code of Canada. One is the impaired driving, and then there is the other one for or 80 and over. An individual gets charged if their ability to operate a motor vehicle is impaired by alcohol or drug, irrespective of their blood alcohol concentration. Whereas the offense of 80 and over only applies when an individual has more than 80 milligrams of alcohol in 100 milliliters of blood. That's when an individual gets charged for the offense of 80 and over. So there are two different offenses. And then there's a third offense that you talked about. That is the refusal. In order for police to obtain evidence for impaired or over 80, they need breath sample from the person of interest. And if that individual or person of interest refuses to provide breath sample, then you get charged for refuse, which is again a criminal code offense and again has serious consequences.
Thank you so much for that, Channdeep. Many people hear about the term careless driving. Can you maybe explain what that means?
We have the impaired driving laws, and then we have the careless driving laws. Impaired driving is an offense under the Criminal Code of Canada. More serious consequences. If someone gets convicted, they get a criminal record, which can thereafter impact the person's ability to acquire a job or go to other countries. Whereas the offense of careless driving, it's encapsulated under the Highway Traffic Act, Ontario Highway Traffic Act, Section 130. Person gets convicted for impaired driving. Yes, your insurance is going to go up. Yes, you may get demerit points. Yes, you may be required to pay a fine, but there is no criminal record. So that's a distinction. One is a criminal code offense. The other one is a Highway Traffic Act offense.
So, Channdeep, if someone wants to avoid a criminal record, is it possible for the Crown to withdraw the criminal DUI charge and exchange for a plea to a careless driving charge under the HTA?
Yes, certainly. Crown attorneys do have that authority to withdraw the criminal charge and lay a new charge for careless driving. However, there are certain prerequisites. When I say prerequisites, your case needs to meet a criteria before the Crown agrees to give you a careless driving resolution. Not exhaustive, but for example, those prerequisites would be usually a blood alcohol concentration of less than 120, no accident, no one should be injured, and the individual should be a first-time offender. So those are some of the prerequisites. And if your case falls in those prerequisites, then certainly Crown attorneys do give out careless driving resolutions, which is actually pretty good. I mean, you're avoiding a criminal charge.
Then let's address the common misconception that if a person decides to plead guilty to a DUI, Can they just ask the judge to reduce it to a careless driving?
So if you plead guilty to a DUI, the answer to that question is no. The power or the authority to lay information for careless driving, that solely rests with the Crown Attorney. Judges, once you have pled guilty to a DUI or impaired or over 80, no, the answer is no. Judges cannot give you or reduce it down to a careless.
What advice would you give someone who is thinking that they can bargain with the judge at the guilty plea hearing?
At the end of the day, the decision or the authority or the power to withdraw the criminal charge and lay a Highway Traffic Act careless driving charge, that rests solely with the Crown Attorney. My advice would be, do not waste your time or the judge's time or other people's time in the court by trying to bargain it with the judge. Rather, before the plea, try to negotiate the deal with the Crown Attorney, and that would likely be more fruitful.
Thank you so much, Channdeep, for joining us today. Thank you to everyone else watching Legally Speaking. Remember, it's only the Crown and not the judge that can offer the careless driving resolution. And don't forget to get legal advice before entering any plea. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.